Ms. O'Brien.
Good morning.
Good morning, Your Honors. May it please the Court, Leslie O'Brien for Anthony Williams. As you know, Anthony Williams was convicted of felony murder in the death of Scott Kelly, the homicide having happened in March of 2004. His claim is that the Superior Court erred in refusing to suppress DNA evidence after destructive testing was performed in the absence of the defense's expert, even though it had been agreed between the parties that the defense expert would have the opportunity to be present.
Well, what would you say the Commonwealth did that was bad here? What did they do that should result in any action that we might take?
Well, Your Honor, that really is part of my point, that the motion judge really didn't take into consideration. He did find the prosecution to be culpable for the selection of the laboratory, but there was really more than that. The state laboratory initially had the evidence in this case. They told the prosecutor a few months after the homicide occurred that the testing would be completed in 8 to 10 months. 6 months later, the state laboratory then informed the prosecutor, now 6 months later on the eve of trial, informed the prosecutor that the testing would not be completed for yet an additional 6 to 8 months, approximately, or 8 to 10 months. So we're talking about an additional 6 months' time that the state police laboratory, which is an agent of the prosecution, that's under Commonwealth versus St. Germain. The police are agents of the prosecution and are required to preserve evidence, and are particularly required to preserve evidence when the evidence has been specifically requested, as occurred in this case. So the lab was remiss in that respect, and I'd suggest that that's...
Well, how? Because of who they chose? Because they sent it with the notices saying, don't do anything till you've contacted the defense attorney.
Not only because of the laboratory that was chosen, but because the state police laboratory, which is an agent of the Commonwealth, the state police laboratory failed to notify the prosecution that there would be this huge delay in conducting the testing.
So
that negligence, it was that negligence that precipitated the rush order, the rush to ship that evidence out to another laboratory.
So maybe they shouldn't have done that, but gone to court and asked for a long continuance, and then the defense counsel would have been saying, no, that's not fair to continue the case for an extremely long time, to give the state lab time to process the thing. It seems to me the Commonwealth was attempting to expedite things by sending the samples off to Cellmark.
Well, they were attempting to correct their own, what I'd suggest is egregious negligence. If a private company did what the state laboratory had done here and failed to notify a client that there would be a delay of an additional 6 months before the work would be done, that would certainly be seen as probably grounds for firing, a contractual breach. This was egregious conduct. This is a first-degree murder case, and the laboratory could not even notify the prosecution that there would be this 6-month delay.
Could I just ask?
If they had,
Go ahead.
If they had taken that simple step, the case could have been sent out to a private lab with no rush order. None of this confusion would have happened. In addition to that, it was the state laboratory that sent those instructions that Cellmark, the private laboratory, said that they found to be confusing. And it was confusing. The instructions to the laboratory, the instructions to the private laboratory was, this is a 15-day rush, but don't start it until you've heard from defense counsel about the defense witness. No priority was assigned to either one of those two seemingly contradictory instructions. So the confusion here, the big rush that occurred and the confusion that occurred at the private laboratory can be or should be directly laid at the feet of the state police crime lab.
Before you get there, I'm sorry.
The lab didn't say it was confused by those instructions. The lab said, we're horrified, this shouldn't have happened.
No.
We received the instruction that you should hold for defense counsel. We always comply with that. This is the only time we failed to. They didn't say we were confused by it. They just said we
Messed up.
messed up.
I have to differ. The affidavits from the representative from Cellmark stated that the instruction was confusing.
But wasn't it
That's
more a reflection that Cellmark was changing their setup some and closing one of their places?
Well, yes, exactly, and that actually overlaps with another part of the
But
analysis
that's not the
here.
state lab's fault,
It's not the state
not
lab's
the
fault.
DA's fault.
It's not the state lab's fault or the DA's fault, but the problem arose because there was this big rush that should never have happened. The problem arose because there was a big rush due to the negligence of the state police lab, and also because the state police laboratory compounded that by sending instructions that were not clear.
Could I ask you this? The Commonwealth argues before you even get there to this sort of willy balancing, you have to have something that's more than fertile imagination that it would have made a difference. And based on, do you just say, well, anything to do with DNA is going to make a difference? I mean, what do you say about that?
No, the standard is, of course, that the defense has to raise a reasonable possibility that there would have been, that exculpatory evidence would have been available if the error had not been made. Now, I would like to also state that where there's been a specific request for the evidence, and that's not disputed, that there was a specific request in this case, the court has said that the burden on the defendant is lighter. This is Commonwealth versus O'Day that I'm relying on, where the court says a defendant who has made a specific request is entitled to relief pursuant to the more favorable standard, whether access to the destroyed or lost evidence might have affected the verdict. Now, the same case does seem to indicate that you still have this reasonable possibility, not probability, but reasonable possibility standard. But this concluding paragraph of O'Day certainly indicates that that standard should not be interpreted, should be interpreted in a way that is more favorable to the defendant than it would be if there had not been a specific request.
Okay, but
And Mr.
So-
Blind, can I
precisely how, though? I mean, what specifically do you say the standard should be, given that there was a request which the Commonwealth failed to comply with?
Well, it isn't, unfortunately, it's not specifically articulated in the case law.
Okay, what do you say it should be?
I say that it should be, I mean, certainly the court could come up with, the court could decide that different wording should be used. I don't think it's necessary. I would use as an example, in the related case to Cherry, the court stated two separate standards for when exculpatory evidence that's been withheld is lost. What the standards would be in the event that exculpatory evidence is withheld, rather, in the event of a specific request and in the absence of a specific request. If you look at the two standards, they appear to be very similar on their face, but they're enlightened by the courts saying that one is more favorable to the defense. So that's really the enlightening factor. The words themselves, I mean, if I can quote from Tucheri, where evidence has not been requested, the standard is the absent evidence would have played an important part in deliberations. Where the evidence has been requested, the standard is a substantial basis exists for claiming prejudice from nondisclosure.
Is that a
Now,
withheld, is tucheria withheld or a lost or destroyed?
Withheld.
Which is-
So I'm suggesting that it's not immediately obvious, just reading those words, that the standards are different. But we know that one is different because we know that it's more favorable to the defense when the evidence has actually been requested. So what I'm suggesting is it's sufficient to simply say, okay, the defense still has to show a reasonable possibility, not a probability, but a reasonable possibility that the evidence would have been exculpatory, but we view that in a more favorable light. We view the defendant showing in a more favorable light than we would if he had not specifically requested.
So in this
the
case,
evidence.
what is that possibility?
The possibility is exactly the evidence, and again, undisputed evidence that there was a great deal of chaos and confusion at the private laboratory at the very time when this testing was taking place.
But is there any evidence that the chaos and confusion actually affected the testing itself?
Well, this is exactly what the expert never got to observe. There is a reasonable possibility based on the descriptions by the representative of Cellmark. It's the representative of Cellmark who said, this was a very unusual circumstance at the
Oh,
laboratory. Things were in a very unusual state at that time. Our workload
they were so unusual that a request that defense counsel they had never known that such a request had not been honored in the past, correct?
That was said.
Yes, so that
yes.
if you have a serious breach, which according to, at least as I understood the affidavit from Cellmark, that it never happened to before, and you told that this laboratory is somewhat in disarray, I assume that you have some reason to wonder what happened.
Well, exactly. And the very fact that the instruction was missed here suggests a level of chaos and confusion. The representative from Cellmark said there was a great deal of confusion at the laboratory because the caseload had doubled in a period of merely 2 months, and also because of the move of cases from Maryland to Dallas also caused a great deal of confusion.
But all that was available to you to be offered to the jury. You could have presented that evidence to the jury. Maybe you did.
Well, there were questions raised about it, but what the defense did not have is the benefit of his expert.
Right. I mean, what
There
you
was a
lost,
reasonable-
what you lost was the opportunity of your expert to examine the process being used with regard to this DNA and be able to testify to any shortcomings in that DNA analysis. That's what you lost. You lost that possibility that your expert may have found something wrong with the analysis that was conducted, right?
With the analysis, but I'd also suggest that the state of the laboratory, which the expert the state of the laboratory at the time of the testing would have been relevant.
But you could have gone, it seems to me the defendant could have made a motion to have the opportunity to go in and observe the laboratory as it was functioning, even not necessarily for this test, but at least in the relatively near future or in a relatively short period of time around when this testing was done.
But the testimony was that this particular point in time was when there was this great deal of confusion.
Well, it wasn't just
Now-
one day. It lasted, the point in time lasted for a fairly lengthy period, didn't it? A couple of months anyway?
I don't recall there being testimony that there was confusion over a lengthy period. I'm just not certain about that. But
I suppose if the theory is that there was haste, get these things done, expedition, your expert wasn't there watching. If you now send in an expert to watch that test, there certainly isn't going to be haste, deviation from a protocol, cutting corners, anything like that.
Yes, I agree with that. And I mean, part of the point is, part of what I'm getting to is what the expert did not have a chance to see is, was the laboratory in itself in a state of disarray? Was there, how were storage matters, how was storage of the evidence in this great press of cases being handled? Did the staff seem exhausted? Did they seem overwhelmed?
But your expert wasn't going in as a consulting firm to be examining the totality of operations. He or she was going to go in, say, I'm here to see Chemist Smith. I'm here to observe a DNA procedure, and you're going to leave. He's not, I mean, you make it seem as if this is going to be Deloitte Touche coming in to do a complete analysis of the method by which this large company is maintaining its DNA operations.
Well, not at all, Your Honor. I'm suggesting that there's a reasonable possibility, based on what was advanced in the affidavits and what was undisputed here, that what the expert would have seen is a laboratory that appeared to be rushed, overwhelmed, with an exhausted staff. That's certainly suggested. And I'm coming back to the burden on the defendant. What if the burden is a reasonable possibility, not probability, but a reasonable possibility, and if that's viewed more generously to the defendant because he specifically requested the opportunity to examine the evidence, this should be enough. That we have the defense losing the opportunity to look at a laboratory that's in a state of great upheaval, see how the...
Ms. O'Brien, let's assume we agree with you, and so we say that this was bad.
Yes.
What's the remedy?
The remedy would be to exclude the DNA testing. That would be the only...
There's no way to send it back and have more testing because it was just a small amount. So
because it was
DNA is out of the case now.
DNA is out. It was destroyed. The defense totally lost the opportunity to...
But you never made a motion to do... There was never a motion to test the blood sample itself. The only motion was to observe the testing that was being done by whatever lab was doing it.
Well, there wasn't enough.
Yes, Your Honor, because the testing was to be destructive. And both parties knew the testing was to be destructive, and that was the reason for the agreement that the testing would be observed.
Did they know in advance that the sample was so small that only one set of tests could be done?
Yes.
Let me ask you, with respect to the balancing process itself, one of the elements is the materiality of the evidence.
Yes.
What is the evidence that you're focusing on in your brief that's material?
Well, it's again, I don't want to be going back and repeating myself, but what's material, or what would have been material here, is the experts' opportunity
No, I think the
to
question
observe.
is
What is the evidence?
The DNA evidence was material in this case, how?
Oh.
No. Actually, my question is, what is the evidence that is material?
The evidence that is, well, it's a reasonable probability of material evidence, and I'm saying that initial burden is...
No. Identify the evidence that you say the materiality of the evidence is the component of the balance, is this particular component of the balancing test, right?
Yes.
What is the evidence in question?
The evidence that I've just been citing. That
Okay, it's not the DNA tests.
It's not the DNA test,
All
we
It's
don't
It's the
know.
opportunity to observe a DNA test when everybody understands that one test will destroy the possibility of the expert conducting its own test.
Exactly, and to
Okay.
be able to see that was done properly, that it was done in a careful way. The Cellmark affidavits say that it requires highly trained people. It requires that a very specific protocol be followed, so that the defense lost what it had been agreed that they would have, the ability to confirm that the testing was actually done according to these very specific protocols, be done by skilled personnel who were not overwhelmed and frazzled. And the defense lost the ability to...
Maybe I'm totally missing this, but in the balancing test, when it talks about the materiality of the evidence, isn't it saying the DNA, where it was found, what it was, how material was it to the actual evidence at trial? Now, this was DNA taken from the car?
It was taken from the car.
I don't think there would be any dispute that the DNA evidence was material. The prosecution fought tooth and nail to make sure that they had their DNA evidence to shore up some shaky identifications and some other problems with the case.
It's the test is the materiality of the exculpatory evidence.
Exactly, exactly. But as the court said in Tuccieri, if evidence is exculpatory, it's material.
I don't think this isn't a redundancy, the materiality of the evidence. I don't think that you can substitute the word expert or exculpatory evidence for materiality of the evidence. Isn't it how powerful the exculpatory evidence is? I mean, there's exculpatory evidence and there's exculpatory evidence.
Yes. Yes, there is, but I'm suggesting that under these circumstances, where the defendant does get the benefit of a lighter burden and should get the benefit of a lighter burden, this was the agreement.
Yeah.
The prosecution messed it up. There should be a consequence. There's been no consequence. There's been an apology.
But if what you say is true, why isn't any time exculpatory evidence lost? It should preclude the introduction of anything that might relate to it.
Well, I suppose it depends in part upon the power of the evidence, and I don't think anybody would dispute that this DNA evidence was evidence that was powerful. And
well, no. It's the power of the exculpatory evidence, isn't it? Isn't that the question? Isn't that exactly what this means? It's the materiality of the lost opportunity to have examined the DNA testing procedure. That's what we really have to look to.
Yes, and that's what I'm relying on, the fact that there was a lost opportunity, that after an agreement that it would be allowed, there was a lost opportunity to examine what went on at that laboratory and to see that it went on properly. And there were indications that it may not have because of the state the lab was in at the time.
Thank you, Ms. O'Brien.
Thank you, Your Honors.
Ms. Huddleston, good morning.
Good morning, Your Honors. Catherine Huddleston for the Commonwealth.
Ms. Huddleston, do you agree with that last point? Is it the materiality of the exculpatory evidence that we need to be focusing on?
Yes, it is. I can jump in and Eddie, but let me come in first to let me take her argument a little bit as she went. First about the claim that there was negligence on the part of some state actor. No, there wasn't, and there's no evidence of that. Any time, any delay that went on because of the backup in the state crime lab was not negligence. You might have that case, you might have that situation if you had a case where you said that the DNA evidence or the blood sample had deteriorated over time physically and that it made it impossible to test. That's not what this case is about. So pure length of time didn't do anything.
Yeah, but isn't the failure of the private lab to follow your instructions, doesn't that fall on your shoulders?
No.
Why?
Because they're not one of us.
Well,
they're
your
The reason
agent.
it went there is because you guys can't get your act together to get it done faster.
Well, we went there. There's no negligence in our choice
Ms.
of this
Huddleston,
independent lab.
They're your agent. Now, they may not have been negligent. They're your agent, right? You ask them to test for you. They're your agent.
They are not. I disagree that the case law says that if we go out and hire a private contractor, an independent contractor, that defense attorneys hire, that other agencies hire, that many people hire, and our only control over that independent contractor is to give them an instruction which they fail to follow, that makes them part and parcel of us.
They're not only your agent.
No. They're
But
whoever, they're their customers.
As to third parties, you're selecting. That's like saying, well, I hired the window installer. I mean, other people hire window installers. I mean,
Right.
you have some responsibility there.
Yes, and there's no evidence at all that the choice of Cellmark was negligent. There is no evidence at all that the Commonwealth knew or had any reason to know that choosing Cellmark, that Cellmark would not follow the instructions that were given to it. So the choice of Cellmark, there's no evidence that the choice of Cellmark was itself a negligent choice.
What do you do with the affidavit of Ms. Floyd, who says the confusing documentation within the case file?
Well, you are going to be looking at that independently.
No, I mean, that's what she says.
That's what she says. But the problem is that when this documentation went to the Maryland office of Cellmark first, they didn't have any problem with it. I'd suggest that, in fact, it's a conclusion on her part that you can disagree with and we would disagree with. I don't think that there is any confusion about it.
Let's assume that I agree with you that they're not your agent. Does that mean too bad to the defendant?
No, it means that one of the three prongs on the second test, which is a balancing test, goes to the Commonwealth. And that gets to where I think we have to get back to is what is the test for this kind of evidence? And I disagree that it's unclear in the cases. There are many cases of the SJC that set out what the proper standard is for reviewing a claim of allegedly exculpatory material that has been lost or destroyed. And it is a two-step test, and your cases say the same thing all the time. Step one, defendant must show a reasonable possibility based on concrete evidence rather than fertile imagination that the lost or destroyed evidence was in fact exculpatory. That is the first step. Only if you've passed that first step as a defendant do you get to the second step, which is that you must show in a balancing test that weighs culpability, if any, of the Commonwealth, materiality of the lost evidence, and potential prejudice to the defendant, that balancing test goes in favor of something like suppression or a new trial. You don't even get to that issue until you get to the first test. Now, when you make a specific request, the only
I think
thing
Justice Gantz was going to ask a question.
It was that question, so continue.
All right. When you make a specific request for certain evidence, what changes is the materiality test. That's part two, all right? In other words, the second step. When you make a specific request for certain evidence, that does not change your initial burden of showing a reasonable possibility based on concrete evidence, not fertile imagination, that this lost or destroyed evidence was in fact exculpatory. So in other words, whether or not you make a specific request, a general request, or no request, your initial burden of showing that there's a reasonable possibility that the destroyed evidence was in fact exculpatory, that's the same.
Well,
it's only the second test.
Here's my concern with that, all right? And I'm not saying that that's this case, but let's assume that the request had come to have their expert be present for it. And let's assume that you had a DA who said, I'm going to ignore that request because nothing good can come from the defense expert being there. I'm just going to have them do it without it. And after all, they're not going to be able to provide concrete evidence of a reasonable possibility. So I can do that without consequence. Is that, by your rule, that's a possibility, isn't it? Isn't there concern that you may not even get to the culpability part if we don't revise the test at least slightly when you have a request that's made specifically to the government?
It's not my rule, it's your rule.
Well, the question is then, should we well, I mean, a Clemente doesn't address a specific request. Clemente is simply, it's just lost. It wasn't evidence which the defense counsel said, please save this, please give this to me, please hold this. It was just lost. Here you have a specific request. If the Commonwealth had blown it off, do you not Is it possible that you don't even get to the balancing test?
It might be possible if they have too vague and speculative a basis for thinking that what got lost was in fact exculpatory.
But here's the problem that I have with that. I mean, I've read these affidavits, and I would say that the picture presented by Cellmark itself is chaos in those labs. Chaos.
I don't think it extends to
I
the
mean,
actual...
well, you may not think, but it's not as if this is a case where it had gone through the normal process. Yes, there was that they had overlooked a request that they'd never overlooked before, but, absolutely everything was done. The impression that you're left is they got too few staff. They're worried about that. They're trying to change their protocols. They're putting too much. They're asking their people, to spend too much time to get the things going. I mean, there's no question that this is a chaotic situation. Now, if there was nothing of that, I mean, this is a situation that at least a reasonable inference is that there was an enormous pressure on these people to cut corners. That, after all, is why you asked to have your expert there, to make sure that they're being careful and they're documenting it carefully and they're taking their time and doing it appropriately. You read those two affidavits, especially the two later affidavits, and that's not the impression that she leaves. Now, the point of her affidavit is a different point. The point of her affidavit is to make quite clear that she assumes the responsibility, and it doesn't go to the Commonwealth perfectly appropriately, that the Commonwealth was somehow calling and saying, go ahead, or, that's the situation that Justice Gantz said. That's the point of her affidavit, but they are single page, single space, double page, two of them. And you can't look at that and say that there's no reason to believe that no corners were cut here.
Well, yes, there is, because there are 3 affidavits.
I understand that.
And her third affidavit is unchallenged and crystal clear that in the testing, the actual STR testing of these samples, there was no corner cut.
Well, that's what
there was no change in protocol. There was no flaw or deviation from protocol. And she presents the raw data. That's that 90-page stuff that the Commonwealth presented. All that we in fact have is that someone or someones in the Dallas lab failed to put 2 and 2 together from the same page, that you're supposed to have the defense expert present. We know that they did not do that.
Right.
We have no evidence at all, and not a reasonable...
Does it trouble you at all that an agreement was not honored and that the defense will never have the opportunity to see that the DNA test was done properly?
It always will bother me that an agreement is not honored. The issue is, what do we do with it, and under what standard do we test it? And what I'm saying is, you have set out the tests, the proper 2-step test for loss of potentially exculpatory evidence. And what you have said in this 2-step process is it is not enough to be saying, I asked for it, I didn't get it, therefore nobody gets it because maybe I can speculate that something went wrong. I've got to show more than that if I'm the defendant, even for lost exculpatory evidence. You have to show that there's a reasonable possibility that what was lost was in fact exculpatory.
What could have been done here? So we have Ms. Floyd saying the technician says she followed the protocol.
You have more than that. You have the raw data, which is all these sheets. And those raw data are showing you that they have all these initials of the people who did the test, and then they are independently verified by a bunch of other individuals who are identified by their initials. All right, so this is not a case where it all came down to, oh, there's one overburdened person, and this person cut corners and submitted this paper, and she's a liar.
Do you agree that...
I'm not suggesting anybody's a liar.
But
Do you agree
you have this raw data that says that all the protocols were followed, and here's the detail of what those protocols were. Here is, tube number 5 was taken out. Gee, that's verified by this second individual. And tube number 6, that's done in a certain way, and here's a third individual who verified that. And those are the protocols that you go through. This is already a process at Cellmark that the court has vetted. We're not talking about a great deal of subjective judgment going on in these tests. It's putting things into machines.
Do you agree that the defendant has met step 1 of the process, that she has made a showing that lost or destroyed evidence was exculpatory?
No, I don't. I completely disagree.
I mean, the fact that Cellmark failed to abide by a simple instruction is not exculpatory? That it doesn't go to the qualifications of the lab itself?
The fact that they failed to follow that instruction
Yeah.
does not show that the tests themselves, that the DNA results themselves.
Then it was irrelevant for the judge to let that question get asked in the course of the trial. The judge permitted irrelevant evidence about the failure of Cellmark to allow their expert access to the testing process.
They can bring that in.
How?
They can say it's part of, they can
It's
say
only-
it's weight and credibility of that evidence
Well,
for the jury.
that's because it's exculpatory, isn't it?
No one was saying that they couldn't bring in the evidence that the test was not, that the instruction was not followed. Maybe I'm not understanding
So
you.
there's some exculpatory evidence as to the competence of the laboratory.
That
by
being
virtue-
that they
Well,
violated
let me
the
finish.
agreement?
Let me
Okay.
finish, please.
Yeah, sorry.
There is exculpatory evidence in the fact that Cellmark Laboratory failed to abide by the instruction, and that in turn reflects upon everything that Cellmark did.
Well, that's the argument that the defendant was allowed to make.
And do you agree that that evidence is relevant in an exculpatory sense? That it is relevant exculpatory evidence?
I guess not. No, I'm
Then
still
in what
trying to-
respect is it relevant if it's not exculpatory?
I guess I'm confused. It's the position the defense wants to make. They want the jury to make what I would say is a leap, that because the instructions to have the defense attorney present were not followed, that therefore the DNA evidence is somehow suspect.
That's
The
right.
Okay, that's the defense claim.
Yeah.
They were allowed to make that before the jury.
And is it because it's exculpatory evidence? Is that the rationale for its admissibility?
I don't think anybody
How
went
else
through
would-
an analysis through it.
It's attacking the Commonwealth's evidence, but the exculpatory piece, if I understand this test correctly, you're looking at it to see whether you should exclude the DNA evidence altogether.
That's what the defense wants to do.
No, but that's what the test is designed to test. Whether the test we're talking about, you go through it, and I'm not saying, your position is it applies here, but it's answered in favor of the Commonwealth. But the two-step test is designed at the end, if the defendant is correct, to keep out evidence that the Commonwealth is seeking to put in, or to somehow, otherwise, that would be the sanction in this case.
Yes, that's the sanction they're seeking.
Right, now I
I'm saying
understand
she used
that,
the wrong if they used the right standard, and if you apply the right one that I say is the right one, and they meet it, then
Right.
then you'd probably be saying that a new trial was required.
Right, but
Okay.
or if it had been applied and the judge had agreed, there would be no DNA evidence in this case. But there being DNA evidence, I think what the defendant was allowed to do was challenge evidence of the Commonwealth like they can challenge any other evidence of
Yeah,
the
I
Commonwealth.
mean, they brought out all kinds of things in cross-examination. He was saying, well, didn't Cellmark once hire someone who put in some fraudulent results? The answer is yes, and she was fired. Did she have anything to do with this case? No. So they learn all that. So in other words, they learned Selmark's not perfect, if you will. How much did that apply to this case? I mean, they learned lots of things like that. I don't think they did any damage to the case. But yeah, I mean, the defense was allowed a lot of leeway in his cross-examination. But that's not really the issue we're talking about here, except again, you can say, well, what really went on in the trial? He was allowed great leeway in his cross-examination, bringing up things arguably irrelevant to this case. And in addition, he got a jury instruction, which I say he's not even entitled to, because why? He didn't pass step one of the lost alleged exculpatory evidence test. But he got it was sort of a Bowden, kind of a missing evidence, and you can infer if you want to that it would have been favorable. He got that instruction anyway. I think he got a benefit he wasn't entitled to. But again, I would say you don't go there because you never get past the first step. I can come back maybe one more time at this test about it. When potential exculpatory evidence still exists, as opposed to is lost or destroyed, what we say is that a defendant must first show that the evidence that was denied him is in fact exculpatory. And we keep that test, that first step, we keep it the same on the defendant, whether or not he made no request, a general request, or a specific request. All right? And I'm saying that you use what changes when is, again, step two, materiality. If he made a specific request, step two, the level of prejudice, that's what gets a little more favorable for him. But that first step, is it exculpatory in fact, that stays the same. And I'm saying that for lost potential exculpatory evidence, the first step, because it's lost, and we all agree it's lost or destroyed, the first step is not you must conclusively prove that that lost evidence was exculpatory, but you must show a reasonable possibility that it was exculpatory. And that first step, again, stays the same for any defendant, whether or not he made a specific, a general, or no request. Again, it's part two, the level of prejudice that you have to show that is going to be more favorable for a defendant who has made a specific request. I mean, this is what we do when we make a specific objection at trial and the objection is overruled, and we come up here, defendant comes up here and says, foul. If as long as the objection was preserved, then you say, was there an error? And if you say, yes, there was an error, then Commonwealth has to show that it was harmless beyond a reasonable doubt. If there was the equivalent of no request or a general request, if there's no preserved error, the defense coming up here still has to show there was an error, and then you go review it under a miscarriage of justice standard. All right? Well, it's sort of the same. You must always show there was an error. You must always show with lost potential exculpatory evidence that there's a reasonable possibility, concrete evidence, not fertile imagination, that that lost evidence was in fact exculpatory. That's what I'm saying. That's why that test stays the same.
So
And then it's the degree of prejudice. That's what materiality really is. That's what is going to become more favorable or less
Ms.
favorable to a
Huddleston, you
defendant.
can answer a question, but you can't go on and on.
Okay.
So my question is, using that framework, then in this case, what the defendant needs to do is show a reasonable possibility that the testing done was negligently done or inaccurately done in some way. Is that right?
He needs to show a reasonable possibility that his expert would, if he had had access to viewing the testing, would have come up with something actually favorable for the defendant, would have come up with seeing a flaw in the actual testing.
Thank you, Ms. Huddleston.
All rise. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justice Court, now set at Boston will be before the Commonwealth. At present, the fact is that in this court is